Good afternoon. Welcome to the session on e-evidence. So what happened? Let me take you back a little bit in time. In April 2018, the European Commission proposed an overhaul of the EU's rules on e-evidence, aimed at speeding up cross-border access in the EU to electronic evidence on crimes such as terrorist plots. Once approved, the new rules would create a separate tool to existing mechanisms of international cooperation and mutual legal assistance. The rules would allow a judge or other authorities to force technology companies to release vital electronic data, such as emails and text messages, to law enforcement agencies within 10 days to as little as 6 hours in case of an emergency. The proposal has since undergone quite a bit of discussion. The EDPB, the body of EU data protection regulators, has called for the new plans to be more in line with EU data privacy rules, and the Council already 2 years ago adopted its general approach, ready to negotiate on the final layout of the rules with the European Parliament. The Parliament, though, still hasn't decided on a final text, and that's kind of where things are at now. We're very lucky to have MEP Birgit Sippel with us on the panel today, because as rapporteur of the plans in the European Parliament's Libe Committee, no one else knows this topic and the minute details as well as her. Mrs. Sippel was reappointed rapporteur last year and has suggested a large number of changes to the Commission's text, including that judicial authorities must be informed if an authority from another EU nation orders the release of electronic evidence from a company in their country. Alongside e-evidence talks in the EU, the Council last year also gave the European Commission a mandate to start talks with the US on an agreement that would ease access to e-evidence and judicial cooperation in the fight against crime. So there's a lot going on, and opinions on what's needed, why, how, and under what form don't all seem to be aligned yet. To find out more about it all, we have with us today Birgit Sippel, who I don't think needs further introduction, other than a lot of eyes these days are on her regarding the future of this new EU tool. Next, we have Xavier Tracol, Senior Legal Officer at Eurojust, the agency that oversees cooperation on judicial matters. Then we have Jeremy Rollison, Director of EU Government Affairs at Microsoft Europe, who can tell us more about the company's perspective, as it would be them having to react to ultimatums on e-evidence access requests. And we have Chloé Berthélémy, Policy Advisor at EDRI, the European Digital Rights Network, who have described the European Commission's proposal as harmful and simply not needed, given there are other tools that are already out there and could just be improved. I now pass the floor to each one of our panelists for some introductory remarks to what I hope promises to be quite a lively discussion today. Birgit, I hand over to you.
Thank you very much, and thank you, Stephanie, for introducing this important file. And you are totally correct. The proposal of the Commission is clearly giving some totally new way of cooperation, because mutual trust between member states so far is defined as mutual trust between authorities. But with the proposal of the Commission, they clearly said, oh, let's make things faster. So let one authority of one member state directly contact a service provider in another member state to get information, meaning to transfer data to that other country. So this proposal was made with the sole purpose, and I think that's also true for the majority of member states who agreed in very short terms, more or less, to the proposal of the Commission. The sole idea behind it was, let's make things fast. And I only would like to make a very small reference that maybe if we want to make things faster, we should better equip our services in law enforcement area. And very often they are not equipped well with the necessary resources. But coming back to the file itself, when doing the proposal, the Commission was clearly forgetting about the fact that regarding criminal law, the conditions in member states are still beyond all the cooperation that is clearly needed. Conditions are still different. So the definition of crime, the sanctions, the means that can be used in one or the other area of a crime. Everything is different, and also the conditions to protect suspected and accused persons are not all the same overall in Europe. So many things need to be debated. Also, we have, as European Parliament, some concerns that there is the impression that some kind of control of responsibility is brought away from public authorities and is given into the hands of service providers. So they should determine if fundamental rights are respected, if the request really is lawful. And that's clearly something that we believe is not acceptable. And therefore, as already mentioned, this Parliament took the task very seriously. We created different working papers. We then met with the shadows to find out where to go, and we added to the text a real big number of changes. So first of all, very important to introduce another member state. So in addition to the issuing member state, the requests do not only need to go to the service provider, but also to the executing authority in the member state where the service provider is. Also, we introduced different lists of non-recognition grounds, both for the executing authority and, of course, for the service provider. And, of course, the legal check on request mainly needs to go to the executing authority. But there might be also reasons that, for technical reasons, because a person of whom you are looking for data is not a client of a service provider. So there might be reasons why even the service provider can't give the answer. And we also refer to some safeguards to that extent. What we also were missing, and that's a very new aspect in the text that only yesterday we agreed upon in the LIBE committee with broad majority, is that we took a decision how to find out if a requesting authority is a legal representative, is allowed to do this request. So we asked for a platform to ensure that the authentication of an authority is ensured, and also to ensure that we have some common lines of transferring data so that the exchange of information is taken place in a very secured way. We also introduced something to inform the users whose data are served. So this should be the principle, but of course, in case where a lawyer says, okay, informing the user would interfere with an investigation, so this would delay the information of the user, but in the end, the user also always has to be informed. And of course, that's also important for sanctions and remedies that we have introduced to that text. Having said this, to give a very small overview on some changes that we introduced into this text to make it more feasible and make it safe and in line with our European laws. We also made it very clear and have to keep in mind that this lawmaking piece is only the precondition for other international agreements. Many of you might have heard about the Cloud Act of the United States. So once we decided about e-evidence, this will clearly be a basis to go into negotiations with the United States. And therefore, we need to be even more important to find out what are the rules transatlantic in the United States, what are our rules, and can we trust to exchange data in the way that is proposed by our Commission. We also have to keep a little bit in mind the sad development within Europe regarding democracy, rule of law, and also corruption, maybe even within governments. So the trust in all our judicial systems is a little bit watered down, and we have to keep that in mind when doing any decision. Some of you might say, okay, if this is so difficult, maybe it's best to reject the proposal of the Commission. To be honest, that might be an idea, but there is no majority for that, nor in the Council, nor in the Parliament. And I think, therefore, this Parliament, on the other hand, took their time to create a better text, to introduce additional safeguards, to introduce a check by the executing authority. And we also included provisions to do our very best to protect immunities and privileges and ensure that if data are sent to a member state which are not needed for a specific investigation, shall not be used and shall not be given to a court, but need to be deleted. I think that's also a very important safeguard. So with all of this, we hope that when starting the negotiations with the Council, to keep the most relevant and most important safeguards on the table to ensure a good cooperation between authorities and providers. But I also would like to underline that there are other measures in place that we can use for cooperation between law enforcement, meaning police, but also the judicial area. And we have to make sure that while exchanging these data and working together, we do not totally undermine, or not even a little bit undermine, the rules that do exist in our member states. If we want to exchange or change the rules in member states and the laws, we have to change the laws, but we cannot undermine the trust in our judicial area by simply following other rules, because without the participation of the executing member state, we might run danger in the proposal of the Commission that we are transmitting data of one country to another for something that might not even be a law in the executing country. So there are a lot of things that we have to keep in mind, and I only can hope that in the negotiations with the Council, they take it seriously, that there are many concerns on the table, that for good reason this Parliament did a long work. And I also hope that those countries who were not in favor for the position that the Council took within very short time frame will also be very outspoken to ensure that with all the need to have a faster procedure within the criminal area, we also ensure fundamental right, the rule of law, because it's not enough to every day talk about fundamental rights and rule of law. We have to make sure that this is presented in practice, and therefore I'm afraid, or I believe, that negotiations with the Council will not be fast, will not be easy, but it's important that we ensure strict rules, not only within Europe, but also with a view to upcoming international agreements that clearly immediately will come up, and where we have to maybe even more careful what we will decide. So that's only a very short overview about some points, and it will be very interesting to exchange with you. Thank you.
Thank you. Xavier, I hand over to you.
Thank you very much, Stephanie, and good afternoon, everyone. Let me start with a disclaimer, which is that I am expressing views in my personal capacity, and that my views do not necessarily reflect those of Eurojust. The fight against crime and terrorism in the digital age must continue to be carried out within a legal framework which is designed to ensure compliance with fundamental rights, including the respect for private life and the protection of personal data. The development of the digital world requires adjustments in many areas, including justice. Access to electronic information has become an unavoidable necessity in most criminal cases, whether or not it relates to terrorism, and access depends on the place of establishment of the service provider. In its proposal for a regulation on e-evidence, the Commission considers direct cooperation in criminal matters between the competent authorities of a member state and a service provider established or represented in another member state, without even having to inform the competent authorities of the state in which the service provider is established or represented. Defining the law and administering justice both fall within the sovereign functions of states. States may judicially cooperate together. Article 82, 1D of the Lisbon Treaty on Judicial Cooperation in Criminal Matters provides that Parliament and Council shall adopt measures to facilitate cooperation between judicial or equivalent authorities of the Member States in relation to proceedings in criminal matters and the enforcement of decisions. The scope of this provision deals with cooperation between judicial or equivalent authorities of member states. It does not deal with cooperation between those authorities and private operators whose objectives are commercial. On the legal basis of Article 82(1)(d) of the Lisbon Treaty, the Commission, however, considers such cooperation between competent authorities of member states and service providers of another member state. The use of this legal basis in the context of direct requests between public authorities and private parties is a novelty. In addition, the Commission considers granting quasi-judicial powers to service providers. Its proposal has the effect of depriving public authorities of member states of their sovereign prerogatives. Article 9, paragraph 5 of the proposal provides that service providers may refrain from executing a European production order certificate if they consider, on the basis of the sole information contained in this certificate, that it manifestly violates the Charter of Fundamental Rights of the European Union or that it's manifestly abusive. Private actors would thus have to assess compliance with the Charter. In principle, these responsibilities, however, rest with member states and EU institutions. In addition, Article 15, paragraph 1 of the proposal provides that service providers may refrain from executing the European production order if they consider that compliance with it would conflict with applicable laws of a third country, prohibiting disclosure of the data concerned on the grounds that this is necessary to either protect the fundamental rights of the individuals concerned or the fundamental interests of the third country related to national security or defense. Service providers thus become auxiliaries of justice, which are endowed with legal powers, enabling them to assess the validity of European production orders notified to them. Service providers are, however, also commercial entities which pursue their own private and financial interests. Easier access to electronic data for police and judicial authorities falls short of justifying such an abandonment of the exclusive powers of public authorities in criminal matters. It also falls short of justifying this confusion between public and private interests. Other means are available to facilitate judicial cooperation in the area of freedom, security, and justice, in which the principle of mutual trust is enshrined. First, the reasons why police and judicial authorities of member states encounter difficulties should be analyzed. US law often applies to service providers. Competent authorities of member states must therefore request the assistance of US authorities, even though the relevant criminal case is often domestic only. The legally correct solution should accordingly be found in improving the treaties on mutual legal assistance which are in force. The US and the EU have already signed such an agreement in 2003. Treaties on mutual legal assistance are criticized since the applicable procedures are both slow and cumbersome. Time is of the essence to enable law enforcement authorities to obtain data which are indispensable for their criminal investigations and prosecutions. The proposal should be consistent with the Council of Europe's second additional protocol to the Budapest Convention on Cybercrime. In the context of its ongoing negotiation, a specific provision has, however, been provisionally adopted on emergency mutual legal assistance. This provision sets out the fastest possible procedure for requests for assistance made in an emergency situation. An emergency is defined as a situation in which there is significant and imminent risk to the life or safety of any natural person. The draft explanatory report provides the example of the case where the location of the victim may be determined through data stored by the provider. The current functioning of treaties on mutual legal assistance can therefore be improved. such treaties are the only available legal instrument to settle the thorny problems of conflicts of law. No available legal instrument solves the case where a service provider objects to a request for the transfer of data notified pursuant to the proposal because the domestic law of a third state, such as US law, does not provide for such transfer. For instance, where the data subject is American. In this respect, the proposal of the Commission does not contribute to resolving conflicts of law when a European production order is notified to service providers to which the law of a third country applies. The proposal of the Commission then provides for referral to a domestic court with jurisdiction over the authority which issued the order. This complex mechanism seems surprising, to say the very least, in the context of a territorial conflict between, on the one hand, the law of the state in whose territory the service provider is established or represented, and on the other hand, the law of the third state, which applies to the same service provider. Second, independently of a possible improvement of treaties on mutual legal assistance, the objective aimed by the Commission could be achieved without calling into question the basic principles concerning the sovereign competencies of member states. Restoring the traditional channel of cooperation between judicial authorities of member states suffices by actively involving the enforcement authorities of the state in whose territory the service provider is located. The draft report of Ms. Zippel proposes a mechanism for notifying the state in whose territory the order is to be executed, simultaneously with sending it to the service provider. The responsibility of legally examining the order and its possible execution would rest with the enforcing authority only. Where appropriate, in the few exceptional cases where the person concerned by the procedure does not reside either on the territory of the issuing state or on the territory of the state executing the order must also be notified to the authorities of the person's place of residence, provided that this place of residence is known, of course. This notification to the affected state is consistent with the sovereign prerogatives of member states set out in Article 82 of the Lisbon Treaty. It is also consistent with striving for efficient procedures. No issue is more sovereign than the protection of personal data. National sovereignty contributes to ensuring compliance with fundamental rights, including the respect for private life and the protection of personal data. If the EU ever becomes a federal state, European sovereignty may then be relied on to comply with fundamental rights. European mechanisms may then also be considered to that effect. But for the time being, relying on national sovereignty remains necessary to ensure compliance with fundamental rights in the area of freedom, security, and justice. Thank you for your attention.
Thank you, Xavier. I hand over to Jeremy.
Hi, Stephanie, and thank you. I'm glad to hear from others, and I do know that we've been talking about this for some time now, so congratulations to the rapporteur for this week's vote. I think we, as a service provider, we welcome the vote in Parliament this week, and I think we welcome many of the changes that I know were not easy to get inserted into the Parliament's draft. And we welcome that because, you know, we're often caught as a service provider in the middle of these discussions. We can appreciate law enforcement's frustration around gathering evidence, trying to do that as quickly as possible in pursuit of solving crimes, etc. But we also have privacy assurances to customers that previous speakers have already highlighted that we have to maintain and we want to be transparent about. So we're always going to follow the law in these instances, but when we get into cross-border cases in particular, the law can also create conflicts that we mentioned earlier. And that's within Europe, not just outside of Europe. So harmonization in this space, I think, is a welcome thing. The more we can do that, the better, particularly as it relates to where we see some of the long-term solutions here, which would be bilateral agreements between third countries and the EU. But in order to do that, we need to be starting from the right starting point. And I think this is a big step forward, ultimately, a proposal like this, towards those more long-term solutions and negotiations with third countries. So again, I think we looked at the Commission's proposal and how quickly the Council indeed adopted a position on that. I think there were many instances where the Council rolled back some of the protections that were in the Commission's text. And so once again, it's been important for the European Parliament, and I think other speakers will address this, to have injected more of those safeguards that would be in there. We can all appreciate the need for more speed in this space, but because of the fundamental rights that are implicated, because of some of the complexities from one member state law to the next, there does need to be adequate consideration, more than adequate consideration, I'd say, around the fundamental rights that are at stake. These are customers ranging from individuals to enterprises who are entrusting their data with service providers. And these are happening increasingly cross-border, so it brings up new issues that might not have been in place from a national perspective, where it's much easier to know exactly which court and under which conditions a service provider can be compelled to share data. I think regardless of where the solutions fall, what's been important for us is some of the transparency that we want to see in this process. At the very least, and I think it's been important that the Parliament has fought for this, and again, deserves praise for making sure that service providers can be transparent and provide notice to their users when their data has been requested by law enforcement authorities. I think that's something that was missing from the Council's text, and we hope that that becomes a key discussion point in trilogue, where we need to at least have the possibility, where it wouldn't prejudice the investigation, of course, to let our users know when their data is being sought by law enforcement authorities with as much detail as we can provide. We have an obligation to do that, and we want to be able to continue to meet that to our users. Moreover, I think the harmonization point is what we talked about earlier. One of the pleasant, I think, or one of the fortunate changes to the text too is, as you said, we've been talking about this in 2018. The harmonization that it can bring is why we see this as a potentially helpful step forward from our perspective, so that we know exactly under which conditions we would be compelled to turn over customer data to law enforcement authorities. The current situation is from one country to the next, new laws are being proposed and new mechanisms are available for countries to make those requests on a national basis. And that does create potential conflicts for service providers that are operating cross-border, not just from a third country, but again, even within the EU. So making sure that if we're going to spend all of this time and effort on a proposal and that it's protective of fundamental rights, let's make that the standard for Europe. Let's make sure that we have the protections there that need to be in place, and that this is the tool that must be used by law enforcement when they're trying to seek data cross-border. If law enforcement can still rely on national orders in this sense, or view the proposal or the mechanism as too cumbersome, and they simply resort to those national orders, I think a lot of the value that we've been highlighting here and the potential value this would have is erased. And it was mentioned earlier that service providers are often in the position of needing to be arbiter of some of the European production orders. And I wouldn't say that service providers are experts in determining fundamental rights abuses, not at all. But in a cloud context in particular, it may often be only the service provider that can become aware of the extent to which an order is inadvertently or unintentionally abusive or overly broad. If you think about requests for data linked to particular IP addresses, the law enforcement authorities nor the court may be aware that that particular IP address is used by hundreds of users, not simply the subject of an investigation. There needs to be a channel there for service providers to highlight those aspects to the authorities so that the rights of others aren't implicated in an investigation that may be only targeting select few. So we certainly wouldn't want to be judge in any of this case. We certainly don't see ourselves that way. But we want to be in a position, we don't want to be judged from one side or the other. We don't want to be forced to automatically compel in every single instance, and I don't think people would want us to do that. And of course, we don't want to be seen as challenging every single thing from law enforcement. We are here to comply with the law, but the law needs to be clear. And we need to have a way to be able to have a dialogue with authorities when what we're requested to provide could run us afoul of those customer assurances, of laws in other countries, and of course, the spirit of the proposal itself. So I would end with, I can understand certainly some of the skepticism, and, it's very hard to come up with perfect solutions here, but it was very important after seeing some of the changes from the member states that the European Parliament indeed looks at this from a fundamental rights perspective and injects the sort of safeguards that would be in there. So a final outcome with the member states does respect those same fundamental rights and has safeguards in place. So this can be an instrument that law enforcement authorities and Europeans can be confident in the use of, and make sure that it's marked by the type of safeguards that we described earlier. We need to be able to ensure that everyone is aware when their data is being accessed, and so far as that's possible, we need to make sure that we're not putting providers into conflicts of law where they're forced to pick the jurisdiction, the law of one jurisdiction or another to break. And we want to make sure that this has the opportunity for those dialogues, both in terms of flagging unintentional or overly broad or potentially abusive orders, and making sure that we can raise conflicts where it may run us afoul of laws in third jurisdictions. So making sure we have that conflict resolution mechanism in place is something that we also would welcome, and make sure that it's maintained during trilogues. So I'll stop there and turn it over to other speakers. I think I have not really disagreed with others. I can certainly appreciate the points. I think the more safeguards that we can put in place from the Parliament's perspective, the better for the outcome that we'd have at the end. So really, once again, I know it's been a hard work, but I think from our perspective, we see the Parliament's text as an important step forward, and hopefully leading to more long-term solutions that do have the same level of respect for fundamental rights and those safeguards. Thank you.
Thank you very much, Jeremy. I'm handing over to Chloé next, please.
Hi, good afternoon. EDRI is European Digital Rights, a network of 44 organizations across Europe that defend and promote human rights in a digital environment. As a civil society network, we strongly support the work of law enforcement authorities, but we also support the cornerstones of our democratic societies as expressed in the Charter of Fundamental Rights. And so do European citizens, actually. We learned in October this year that nearly 8 out of 10 Europeans support the conditionality of EU funds to the respect by national governments of the rule of law. And if the EU should not financially support member states that trample democratic principles, it should neither grant them sweeping powers to access people's personal data and private information. It's quite recurrent EDRI's analysis that we live in a golden age of surveillance, because the use of technologies gives the investigative and prosecuting state authorities access to more information about people's private lives than ever before. And therefore, the interference with their freedoms and rights is unprecedented. Think about how it became almost daily news that we discover that some private companies or one dynamic startup offered their new innovative monitoring software, their brand new data scraping tool, or their big data analytics to police forces, even here in Europe. And the e-evidence proposal is nothing less than the continuation of this ongoing power relationship in which we citizens, people, are quite losing. We have fundamental concerns with the proposal, too many to list today, ranging from the legal basis, which was already mentioned, and the lack of access to remedies, for example. Other panelists already took the time to present the problems regarding the Commission's proposal and the Council's text. So for the sake of today's debate, I will focus on our core concerns about the recent adopted Parliament's position in this brief introduction. The general assessment is that the Parliament had a great opportunity to come at the negotiation table with the Council with strong safeguards for people, notably whistleblowers, journalists, doctors, lawyers, etc. It kind of missed it, although there are lots of improvement, and it's almost like black and white compared to the Commission initial proposal. It's still a shame they did not carry their initial ideas through, the ones that were reflected in the rapporteur's original draft. So I might need to recall that the final text we will see at the end of the process won't look like the Parliament's current report, given that the Commission and the Council's position they don't have interest in subjecting cross-border access to data to proper safeguards. So first remark, the introduction of a notification to the affected state, which is the authority of the member state of permanent residence of the person whose data is being accessed. It is without doubt the major improvement introduced by Mrs. Sippel's draft report. Unfortunately, the affected state is no longer consulted or required to validate production orders in the latest Parliament's text, and therefore it is unable to block infringing foreign data requests. This is very unfortunate because this member state of residence is usually the best placed and has the legal responsibility to protect affected people's fundamental rights and procedural rights, and to know about potential special protections and privileges. This also creates barriers to a certain extent for the affected person, notably their right to access to justice, because they have to go defend themselves in other countries where they might have never set a foot in before. Second remark, the notification to the executing state is incomplete and not robust enough for production orders seeking subscriber information and IP addresses. Notably, the service providers are required to hand over data as soon as possible and within set short deadlines, as we mentioned it in the beginning, without waiting for the validation of the executing authorities. And so, firstly, this kind of direct effect of production orders is questionable if you think about the principle of territoriality, because it enables an authority to extend its enforcement jurisdiction beyond their own national borders. And then secondly, the report kind of foresees that in case the executing authority objects to an order, but that it objects it after the data was already transferred, the issuing authority must erase the data that they already obtained. So production orders requesting subscriber information and IP addresses, they usually aim at getting the information about the identity of a person, at identifying a person. So it's difficult to imagine how issuing authorities will suddenly forget the person's identity and stop the investigations there. For example, if German authorities find out a suspect's name is Olaf Scholz, then it is too late. This eraser clause, so to say, will therefore provide little to no protection in practice against abuse. This is why we requested that it should be mandatory for the executing authority to give its explicit approval before any production order can be executed. I think it cannot be stressed enough, this principle, and the importance of systematic involvement of judicial authorities in at least 2 different member states for the enforcement of cross-border investigative measures. I mean, all of them, all investigative measures, not the ones that are considered more intrusive than others. This ensures that the European system of mutual recognition, which involves the peer review of judicial decision, is working well, but also it maintains trust in the EU criminal justice area, which is based on the rule of law. I highlight this principle in a context where a court in Amsterdam stated that the Netherlands will stop extraditing suspects and convicts to Poland over concerns that their courts are no longer independent. And if you think about it, this Dutch decision is even more significant considering the recent political developments related to the COVID-19 crisis in several member states, which, among other things, undermine the independence even more of judiciaries. Lastly, it is important to learn from experience and try to adopt policy decisions based on evidence. The justification for the e-evidence proposal is that existing judicial cooperation instruments, including the Mutual Legal Assistance Treaties, MLATs, and the European Investigation Order, EIO, are ill-suited to the current needs of investigative authorities for data gathering. It might be well true that current practices and experience of mutual legal assistance treaties might not be up to the job, but current practice not being up to the job doesn't prove that it cannot be vastly improved. For example, thanks to a US MLAT reform program already put in place a couple of years ago, that increased the resources to handle MLAT's requests, the US Department of Justice reduced the amount of pending cases by 1/3, so vastly improving the efficiency of the process. Similarly, the European Investigation Order, the EIO, is gradually improving, like national authorities becoming increasingly more aware and acquainted with this new instrument, which was only adopted in 2018. And actually, I learned just like 2 days ago, the EIO was recently used successfully and help in bringing down a massive organized crime network in Europe, leading to thousands of arrests across 3 member states, Norway and the UK. Likewise, in urgent cases, it's possible to have real-time cooperation through facilitated through Eurojust and national desks. As a result, and those are my final remarks, we believe that the evidence proposal needs to be fundamentally reconsidered or rejected at best. We propose that instead, the legislative action focus on learning from the experience from the EIO implementation, identifying how the EIO can be improved in order to address all or most of the problems, fixing first the procedural issues of the MLATs, not the substantive ones, by allocating a bit more resources to the processing of requests. And this is where I join Mrs. Sippel's call for more funding of competent public services. And lastly, ensuring that safeguards are in place to guarantee that the least restrictive measure is always used first. Thank you for your attention.
Thank you very much, Chloe. So we open a little bit of a discussion round now. I'm going to start with Birgit because I said initially all eyes are on you to see where things go now and next. You also said that generally there is no majority in favor of basically just annulling the Commission decision. So that seems to be a given. It's a good, the Commission proposal, it's a good proposal, and there should be such a new, an overhaul of the laws on cross-border e-evidence access. But where do things stand in the Parliament? What do you think in terms of a timeline of when the Parliament will be ready to enter the trilogue? And also, how hopeful are you that the majority of your changes will be acceptable? Which are the changes that you just will not compromise on, that you will not let go of? Which are really the key changes that you think have to pass? Otherwise, it's not acceptable for the Parliament.
That's a very complex question. So first of all, as I indicated in my introduction, only yesterday in Libe Committee, we took a decision on the Parliament's position. So now the next step will be next week in plenary, where this decision of the Libe Committee needs to be confirmed, or it could be rejected. So but I really hope it will be confirmed, and the confirmation will be on the question if we should start trialogues. So having that in mind, trialogues together with the Council then, as we are nearly end of December then, can only start beginning of next year. So, and the question, how long will it take to get an agreement together with the 3 institutions? That's a question I can't answer by now. So I would like to come back to the example that Chloé just mentioned on the fact that court in Netherlands decided not to extradite people to Poland. We also have in mind the current debates about the rule of law, the general idea of rule of law, but also the rule of law in combination with the budget. And it seems, to be honest, for maybe the first time in the last 10 years, that member states start to get a little bit tired of always talking about some member states who don't respect rule of law, the independence of judiciary. And it seems, I'm very careful here, it seems they might now take a stronger position on that. Having that in mind, I only can hope that this also leads to maybe a different approach to the idea of evidence, especially in the Council, but hopefully also in the Commission, to take more serious notice of the different level of the judiciary in the member states, of the conflicts of law that clearly can come up when cooperating directly with service providers. And it might also happen that we can ensure the better protection, especially of people with immunities. And even though, unfortunately, during the negotiations with the other shadows, we had to give up the affected state because in the first run there was no majority for that. I will not give up to bring in the idea later on, because especially if we want to protect immunities of journalists, of lawyers, and many others, and having in mind that this still is regulated in only national laws, who better than the affected member state can take a decision if special information are protected by immunities and privileges or not. So there might be a link to come back to some ideas in general to protect persons, but also to protect to some extent the legal system of member states and to hold up the trust of citizens into the still national system is something that we have to uphold. And therefore, I will clearly work to ensure all the safeguards that are in the text, all the reasons not to accept a request from the issuing country. You might have seen there are different reasons to reject a request, both for the service providers, but also for the executing state. And up to the very last minute, we really had serious debates about how to best ensure especially immunities and privileges. So these things are the most important to keep up in the negotiations. And if that means we can't take a decision within next year, okay, then that's it. And we also have to keep in mind that we have to improve the cooperation between national authorities and Eurojust, because Eurojust might be the focal point to collect all the information about different systems to ensure that the knowledge when taken one or the other decision is always there. So upholding the safeguards, trying our very best to inform users and give them chances for remedies, but also ensure immunities and privileges by one or the other way to strengthen this will be the main points that I will focus on when negotiating with the Council and the Commission.
Do any of the participants want to respond to Birgit on this? Chloé, I see you get unmuted.
I got unmuted? No.
I mean, EDRI has made its position.
Yeah,
Go ahead.
EDRI has made its position quite clear, and I completely understand Mrs. Sippel's position. I mean, we are a civil society organization. We are here to exchange with policymakers. We're not the ones doing the compromise in the end. So we have this easy position. And we really supported Mrs. Sippel's approach in 2019. And it's just very underwhelming that other groups could not join this joint efforts to repair what we consider an unrepairable proposal. But the ideas were there in the original draft report. It's just the reality of the political game makes the current proposal something we can't get behind. We hope that Mrs. Sippel and the other shadow rapporteurs will get support from other member states, and notably the 8 ones, I think there were 8 who criticized the approach of the Council because they agreed to a general approach so quickly, like in a matter of few months. And this was done so fast that certain member states kind of almost forgot that this was going on and realized too late that it might be a big problem in terms of their constitutional protections. So we hope the Council can move forward on this proposal as well and try to make it less harmful than it was originally proposed.
Thank you. Jeremy, companies like yours are kind of squeezed in the middle. of this debate. I hear a lot of consensus in a way when I listen to all the panelists about what's been in the Commission proposal on access requests to service providers and the concerns that have been expressed by having direct access requests from judges in one member state to service providers based in another member state. So that's where it's nice to have you on the panel. How do you, what you make of being put in this position of becoming a direct target by law enforcement in judicial cooperation? I mean, you mentioned already in your introductory remarks that harmonization is important for you, the protection of fundamental rights, and there needs to be clarity and certainty. And that seems to kind of also reflect something I saw recently in a joint press release or comment piece by Eurojust alongside Europol and the European Judicial Network. They said that one of the challenges in retrieving key evidence was that companies have different standards when cooperating with authorities. So that's also something that these new proposed EU rules would obviously address. So this harmonization also on that front. I mean, how much are companies like yours able to contribute to the debate, and how are you trying to bring your position across better? And are you hopeful that it will be heard?
Well, we're always hopeful. We're always hopeful. I think, listen, the rapporteur started off by talking about what a complex issue this is. And, you can't understate that. You mentioned different ways that companies can respond to law enforcement, different levels of cooperation. And that can be because of whether company cultures, that can be because of very, very different business models, that just technologically, some of this is much more challenging. It's much different when you're just asking for a straightforward list of phone records, perhaps, than when you're asking for gigabytes and gigabytes of data, or you're asking for a really particular piece of information from a particular conversation on a particular platform. These things are complex, and it matters whether that company is based in one member state or another, maybe not based in the EU at all. These things can get very complex. And again, for the same reasons that Chloé and the rapporteur mentioned earlier, we're caught in the middle very often of that. It may be fine for one member state and have to have laws in place to say that this is a crime here, we need evidence to support it, and we're coming to Microsoft as an Office 365 provider. But if making such a disclosure would run us afoul of Irish law or run us afoul of even EU law, potentially, who do we turn to say that? Where do we raise that point? Because if we just comply, Chloé's not happy. I don't think the rapporteur is happy. I don't think our customers are happy, even though one investigative authority may be happy. And if we don't comply, then somebody else is not happy. So we have, I think, it's all relative, but I think we have very good cooperation with law enforcement, generally across the board. I think it should not be missed that some of the cases we're talking about here are a smaller fraction of the cases that the broader space would apply to, but we are talking about things where cross-border requests are implicated, third countries are potentially implicated, differing laws and cultures are implicated. This is much more straightforward when we talked about it in a national context with certain types of data. Once you broaden that out, it gets much more challenging. And it gets much more challenging because in that space, it's mentioned on other panels today, the importance of trust. It's very hard for us to maintain customers if we can't even tell them under which conditions their data can be accessed. They may not like the conditions under which that data is accessed because those are conditions set by law, but we don't set the law. But it's even difficult for us to answer honestly and comprehensively about the conditions under which that data might be accessed. And that's not a good place to be. I don't think it's a good place for a customer to be, and it's not a good place for us to be. So I actually don't disagree with, I think much of what Chloé or Xavier said at all. This is a complex space, and I think the more safeguards that we can put in there, the better, to help reassure customers, reassure citizens. But we are caught in a problem right now where a solution would be helpful. And this is an important step forward. And I do think there's been a lot of work done to put those safeguards in the Parliament's text. And I hope that the rapporteur is going to win many of those fights. So.
Thank you. I'm going to take a question from the audience as well, because there's this other discussion that we haven't really discussed yet. So we'll do that very quickly before time runs out. The question is regarding the EU-US agreement to facilitate access to electronic evidence in criminal investigations. How do you panelists see this going in the future, considering the current geopolitical context? And of course, also bearing in mind what happened in July at the EU Court of Justice when it ruled on the Privacy Shield. So that's the EU-US data transfer agreement. Who wants to go ahead with answering maybe this question, please? Xavier?
Sure, I can volunteer to try. I mean, these negotiations are obviously very complex, and they're just starting, so they will take a lot of time. The geopolitical context is favorable, obviously. I mean, in the US, we have a new administration which is more open to relations with the EU. So you know, the context is very positive, and I don't think there is any fear there. The negotiations of these kind of instruments, you know, again, always takes a lot of time, but, you know, once they are in place, you know, they really provide added value. And if we look at the example, for instance, of the EU-US agreement on mutual legal assistance that I referred to earlier, it dates back to 2003, so it's almost 20 years old. I'm not claiming in any kind of way that this is a very easy road. You know, sometimes there are tensions between the two partners, but, you know, we meet regularly to try and find a way. I mean, those are instruments which are designed for practitioners. So, you know, of course, the negotiation of these instruments is at a political level, and it's, again, not easy. But once they are adopted, it's up to the practitioners to make them work. And there is a clear willingness on the two sides of the Atlantic Ocean in order to make them work, for a simple reason: they are necessary. So it's a necessary cooperation. Now, regarding the Privacy Shield, I mean, we're talking about a totally different animal there. I mean, the Privacy Shield used to apply in the commercial context. We're no longer talking about cooperation in criminal matters here. And this adequacy decision actually was used in order to transfer personal data from the EEA to the US and vice versa. So this legal basis is no longer available now, but it does not imply that other legal avenues are not available. We still have, you know, appropriate safeguards. We still have binding corporate rules. You know, of course, the judgment of the Grand Chamber of the Court of Justice is very far-reaching, and it applies, among other things, to appropriate safeguards and binding corporate rules as well. So, you know, for the time being, I would say that the easiest option for companies interested in transferring personal data from the EEA to the US is, to the extent possible, not to transfer this data and keep it in the EEA. There is a ongoing consultation by the DPS about the supplementary measures which are mentioned in the judgment of the Court of Justice for appropriate safeguards to adapt these appropriate safeguards to the judgments of the Grand Chamber, but that will again take some time. So it's not easy at the moment to find a safe legal ground in order to transfer personal data from the EEA to the EU. Another instrument which is available is derogations, but derogations are exceptional by nature. So for one-off transfer, it's okay to use a derogation. If we're talking about, you know, a systematic transfer of personal data, this is not a legal ground which is available, obviously. But, you know, again, we're talking about very different animals here between the negotiation of an agreement between the EU and the US and the validation
Absolutely,
of the Privacy
but it also
Shield.
goes to show, don't ever forget the EU court. It's there at the end somewhere, and it may always have a final say and raise the bar far, you know, very high, as as to what you could imagine, like it did with data transfers. And that has also implications now with Brexit. But anyway, that's a discussion for another time. I'm afraid that's all we have time for on e-evidence today. Thank you so much for your time. And I'm sure there's probably more questions out there, but we'll have to see how to address those another time. I'm now going to introduce the session 5 of this conference, which is about e-privacy, cookies, and data retention. Can a future-proof framework fit for the digital society be achieved? Thank you very much, and have a lot of fun for the rest of the day.
Thank you. Bye-bye.